Hi everyone, Andrew Schultz, Principal Broker with Own Buffalo Inc. here, and today I wanted to bring you some breaking news coming out of Albany, where Governor Cuomo has signed a new piece of legislation that effectively prevents you from evicting a tenant for non-payment of rent for any sort of rent incurred during the COVID-19 crisis. So I'm going to jump right over to our desktop here, and we're going to start with part of a press release issued by State Senator Brad Hoylman's office, the Tenant Safe Harbor Act provides protection from eviction for renters who have experienced financial hardship during the COVID-19 state of emergency. This legislation prohibits courts from ever evicting residential tenants who experienced financial hardship for non-payment of rent that accrues or becomes due during the COVID-19 period. It would apply to any unpaid rent accrued between March 7th and the yet-to-be-determined date on which all COVID-19 related restrictions on non-essential gatherings and businesses are lifted. This legislation builds upon the protections of the current eviction moratorium. Prior to the Tenant Safe Harbor Act, a tenant who was unable to pay rent during the COVID-19 crisis could be evicted for non-payment as soon as the moratorium ended. Now, because of the Tenant Safe Harbor Act, a court can never use unpaid rent that accrued during the COVID-19 period as a basis for non-payment eviction of a financially burdened tenant, however, could impose a money judgment. So we'll jump over to this. This is the actual New York State Senate.gov website, and you can see the current bill status. This is the bill S8192B, and you can see that this has made it all the way through the process and has been signed by the governor, which effectively makes it law now. So I'm going to pull up a PDF copy that I've taken some time to highlight for you. Let me just switch over to hand icon here. And you can see that this is floating around for a couple of months before it finally made it through. So it did take time to hammer this piece of legislation out. However, a lot of these pieces of legislation are being hammered out way behind the scenes where you're not getting really updates as to what's going on. And then all of a sudden it just suddenly passes. So we'll scroll down through here. Section 1, for the purposes of this act, COVID-19 covered period means that March 7th, 2020, until the date on which none of the provisions that closed or otherwise restricted public or private businesses or places of public accommodation, et cetera, et cetera, et cetera. There's no end date to this. This runs from March 7th until New York State decides that we're no longer in a state of emergency as a result of COVID-19. No court shall issue a warrant of eviction or a judgment of possession against a residential tenant, so this doesn't apply commercially, or other lawful occupant that has suffered a financial hardship during the COVID-19 covered period for the non-payment of rent that accrues or becomes due during the covered period. A tenant or lawful occupant may raise financial hardship during the COVID-19 covered period as a defense in a summary proceeding under Article 7 of the Real Property Actions and Proceedings Law. So essentially what will happen is you'll have to begin your whole process, get to the point where you get to court with this tenant, and then they raise the financial hardship as a defense at the time of the eviction. In determining whether a tenant or lawful occupant suffered a financial hardship during the COVID-19 covered period, the court shall consider, among other relevant factors, 1. Tenant or lawful occupant's income prior to COVID-19. 2. Tenant or lawful occupant's income during COVID-19. 3. Tenant or lawful occupant's liquid assets. 4. Tenant or lawful occupant's eligibility for and receipt of cash assistance, SNAP assistance, supplemental security income, state disability, HEAP, unemployment insurance benefits, or under state or federal law. So essentially, the court is supposed to take the time to look at the before and after income of the tenant and determine whether or not they're impacted by COVID-19. There's so many gaps and loopholes that can be pulled out of that, it's ridiculous. And then the last thing that we have highlighted here is that this act shall take effect immediately. So this is law. This is law as of June 30th. So this is official law here in the state of New York as of June 30th. This now is the law of the land. And we're now in a state where effectively, if a tenant is accruing debt as a result of COVID-19, you cannot pursue that eviction. You cannot pursue an eviction for non-payment for that debt during or after coronavirus, is the way that I am understanding this. All that being said, I'm not an attorney. You should certainly have a good attorney on your team if you're going to be a housing provider here in the state of New York. If you need a referral to an attorney, please feel free to reach out and we could certainly help you, at least here in the Western New York area. Guys, thank you so much for watching. Again, I'm not an attorney. I do strongly recommend that you speak to your attorney on this, but it looks like this is going to be the way things are moving forward. If you have any questions, feel free to reach out to us, either at our office on our Facebook page or via phone, 716-608-3200. Thank you so much for watching. Please share this video if you know someone who's a housing provider in the state of New York. Share this video with them. Let's make sure that everyone stays educated on what's going on in our state.